Good. So thank you very much. Good evening, everybody. My name is Teresa Shaver. I'm the CEO of the Business Advisory Center Durham. I've had the pleasure of working at this location for the last 10 years. And tonight I'm really excited to have Olga Leyenson, a referral partner of BACD. So they work closely with our clients from Gobin and Leyenson, and we're going to go through the litigation for businesses before the small claims court. So many times, unfortunately, when you are in business, there is an opportunity where you might have to try and get money from your client, but they're also going to talk about other types of litigation as well. So tonight we have Olga and we have Kimberly as well. Both are licensed paralegals. They work with civil litigation, employment law, and human rights disputes. Olga, I'm sure you'll tell us a little bit more about your company as well before we get started. BACD, Business Advisory Center Durham, is a not-for-profit. We're one of the 54 small business centers in Ontario that are here to help businesses get started and growing. Tonight we also have Community Futures. So Community Futures is a similar corporation to us in that they also support small business, getting loans and getting help and advice with their business plans, and they are mostly in rural areas. So there's a fairly robust network of entrepreneurship support in Ontario. In fact, Ontario, for small business centers, it's the only entrepreneurship network in Canada. There's others, like CFTC is actually even more robust than we are, but we are the Ontario Small Business Center Network, and BACD is one of those. We've been around for 20 to 30 years in different communities, helping entrepreneurs get started, growing, entrepreneurial funding programs. We run workshops like this as well. So anything that we can do to educate and to give entrepreneurs the skills, the tools, the knowledge that they need to be successful in business. So thank you for being here. And Olga, over to you. I'll be in the background.
Thank you so much, Teresa. Hello, everybody. Thank you for attending this presentation. Just by way of a background, my name is Olga Leyenson. I'm one of the partners at Gobin Leyenson LLP law firm in downtown Oshawa, and we provide a variety of services, including civil litigation before the small claims court. We have a number of paralegals on staff to facilitate our clients' litigation questions, concerns, and matters. And one of our associates, Kimberly Holt, is with us today. She's going to be assisting me and walking you through some of the litigation aspects before the small claims court. I've been a paralegal for over 20 years, and I've been employed as long as I have been a paralegal. So we have a clear understanding of the challenges that small businesses face, especially over the past couple of years as a result of COVID-19 pandemic. So I'm going to ask Ms. Holt to provide a brief introduction about herself before we move on with tonight's materials. Kimberly?
Thank you, Olga. So yes, I am also a licensed paralegal. I'm employed at Gobin Leyenson LLP. I actually first started with Gobin Leyenson LLP when I obtained my license, and then did branch off for a little while into my own private practice, where I had Kimberly Holt Paralegal Services, and then returned to Gobin Leyenson LLP. So I specifically work on human rights, employment law, small claims court, and I have done landlord and tenant board as well in the past. So I'll pass it back to you, Olga, and go from there.
Thank you. Okay, so I just want to quickly mention that what we discussed today is meant as a general information for anyone attending. Each case should be viewed on an individual basis, and we are not today providing any legal advice. You are absolutely welcome to contact our office, and especially if you're a member of the Business Advisory Center Durham, we're more than happy to provide a complimentary 30-minute consultation for your particular small claims court matter. So the information we covered today is just a general overview of litigation before the small claims court. Civil litigation in general encompasses a variety of type of matters, from breaches of contract, employment law, personal injury, even return of personal property. Today, we're going to talk about civil litigation in relation to breach of contract before the Small Claims Court. The Small Claims Court in Ontario is a branch of the Superior Court of Justice. And over the past couple of years, their jurisdiction has increased from $25,000 to $35,000. Now, the $35,000 monetary jurisdiction does not include out-of-pocket expenses associated with bringing lawsuits before the court, any interest that you might be seeking, or any costs associated with litigation. So when we talk about the maximum monetary jurisdiction of the Small Claims Court, it's directly related to the actual amounts for which we're going to be suing. Small Claims Court can award damages, in other words, the amount of money that you're seeking, but it can also make an order requiring a party to return personal property within the monetary jurisdiction of the Small Claims Court. So we'll talk about breaches of contract, but first let's take a look whether or not we should sue. Kimberly?
So one question that comes up is, should I sue if there was a breach of contract? So before we get into the details and discuss a breach of contract, let's touch base on what a contract is. And I know this might sound elementary to many of us who've entered into some type of contract at least once in our lifetime. You know, you buy a coffee, that's a contract, right? So whether such contracts were legally binding on the parties is not always so elementary to discuss, and nor is it clear without a legal analysis. So a contract, for your reference, is an agreement between two or more parties that the law recognizes and will enforce. So such contracts must have certain features in order to be recognized as enforceable. So firstly, as you'll note on the slide, there's the intention to create a legal relationship. So what does that mean? That means that there's an intention of the promisor to be bound by the promise that they made. 2, an offer and acceptance of the offer. So for this to come into play, one person must offer something and the other must accept it. And a mere statement of a person's intention to enter into negotiations is not an offer and cannot be accepted as to form a valid contract. The acceptance must be in the entirety of the original offer without any changes. 3, an exchange of something of value, or what we call consideration. So what is consideration? It can take many forms. Most often, of course, consideration is a payment of money. However, consideration can also be goods and services, or even agreement to specifically do something. Or donation of funds or promise of a donation is often not recognized by the court as consideration for the purposes of enforcing a contract. So that's important to know. And then we'll get to legality. So what is legality? It basically determines whether the contract has a legal purpose. And it cannot violate any law or public policy. And the persons entering into the contract must be of sound mind and legal age. So some exceptions apply, but legal age, we mean the age of majority, 18 years old. So many contracts are subject to various laws that make a valid contract unenforceable. So, which may make a part of the contract unenforceable. So for instance, some provincial laws may prevent the business from continuing legal action if the laws were breached. And I'll pass this over to Olga. She's going to provide you with some examples as what I'm referring to. Olga, I'm just going to let you know you're muted.
Thank you so much. God bless technology. Okay, I apologize for that. So some of the things that we often see with our clients when they approach us for assistance on breaches of contract is that the contract may not be enforceable. While it may contain all the necessary elements, if the business has breached some provincial law with respect to their conduct or the content of their contract, either the entire contract or part of those contracts may not be enforceable by the court. One of the examples I can bring is the Business Names Act. It is a provincial law that requires all the businesses to register their operating name. So if I was to operate a paralegal business under Olga Leyenson being my legal name, I don't have to register it. But if I was to operate as I am now under the name of Gobin and Leyenson LLP, that name would require registration. While the contract between Gobin and Leyenson LLP may still be enforceable if I fail to register the name, what will happen is that I would be unable to maintain legal action until such time as I actually request and obtain permission from the court in light of my failure to register the name. Another example is the Consumer Protection Act. This provincial law applies to most contracts that are created and entered into the province of Ontario between a business and an individual consumer. It does not apply for contracts entered between two businesses. For example, an automotive mechanic would provide an estimate to their customer for the purpose of repairing a vehicle. And subsequently, they would provide an invoice. But if the invoice for the services has exceeded the estimated amount by more than 10%, that mechanic may find themselves in front of a judge who's unable to enforce that invoice for the purpose of payment. In addition, any contracts that contain any ambiguities between a business and an individual would be interpreted to the benefit of the individual consumer, not the business. So to answer the initial question, to sue or not to sue, would mostly hinge on the answers: was there a valid, enforceable contract, and has the business complied with all the necessary applicable requirements that govern that particular contract? Kim?
Just going to wait for you to, I'm not sure if the slide is changing there. Perfect. So now that we have a general idea of what is a legally binding contract and what it requires, we can discuss what a breach of contract is. So in general, a breach is a failure without a legal excuse to perform any promise that forms part of a contract, or as we have it, a violation or infraction of a law or an obligation. So there's different types of breaches that can amount to a breach of contract, and we've outlined some of them here. So firstly, repudiation is to renounce or reject an obligation. Express breach is a failure or refusal to perform the obligations when the obligations become due. Anticipatory breach is an express repudiation that occurs before the time of performance of the contract, and it's unequivocally indicating that the party will not perform when the performance becomes due. An implied repudiation is not express, and it must be implied or deduced from the circumstances. And moving on, fundamental breaches are breaches that refer to failure to perform a primary obligation that's under the contract. So which indeed has the effect of depriving the other party of substantially the whole benefit of the contract. So any litigation carries some risks and of course some expenses. And while small claims court process is typically faster and cheaper than proceeding with the superior court claims, today the cost of litigation and the delays caused by COVID-19 have indeed escalated substantially. So what's important to note is that subject to the type of breach and the consequences of such breach, the injured party should consider their options carefully before jumping into legal action. So like we said, it's always important to consult with a legal professional to ensure that you understand all the options going forward and what that could mean for you?
So we have a valid enforceable contract, check. We have a breach of contract, check. And now we're eager to sue. But as any legal professional will tell you, there are additional factors to consider before we jump into legal action. Limitation period is one. Now, generally, a breach of contract type claims is subject to a 2-year limitation period after the breach has occurred. So if your customer or your supplier has breached the contract, from the day the breach has occurred, you will have generally 2 years to pursue legal action. Keep in mind that failure to start a lawsuit within that 2-year limitation period may result in you losing your ability to sue forever. The other factor to consider is the cost of litigation versus the amount you're suing for. Even as a self-represented party, which many litigants are before the small claims court, the cost of litigation may still be considered. Out-of-pocket expenses, such as court filing fees, are currently $102 to file the lawsuit and $249 to request the day of trial. So we're looking at over $400 without even obtaining any legal representation or without even taking time off away from your business to pursue the litigation. Consider the time to prepare the lawsuit, to serve the lawsuit, ensuring that it's done properly, time necessary to gather the evidence, and obviously the time that you will take to attend court hearings. And any additional expenses that the business will incur in addition to the loss that they have already suffered. Is it really worth it? Now, the other consideration, and it's probably one of the most important considerations, are you going to be able to collect from the person that you're suing? Many litigants before the small claims court don't always consider whether or not collecting the money that they are awarded at the end of litigation is possible. If the party, the business, or the person you're suing has no assets, has limited to no income, then the chances of your ability to actually collect the money that the court awards you is very limited, or maybe even none. So at the conclusion of the trial, if you are successful, the judge will make an order in your favor, awarding you whatever amounts that you were able to prove. But you will be required to take additional steps and incur additional expenses in order to enforce that order, that judgment, if the party does not voluntarily pay. The time to conduct litigation, as Kimberly mentioned, as a result of COVID-19, most courts and tribunals have encountered severe backlogs, which resulted in delays. That is also a factor. While the courts have reopened, they have been operating at a slower pace, trying to resolve the substantial backlog that occurred throughout the shutdown. Currently, we estimate that the average small claims court case will take about 2 years to conclude from the time you begin the litigation. During this period of time, the party you are suing could dispose of their assets. They could proceed with bankruptcy, which will ultimately eliminate any potential ability to recover any awards that you may be granted. Exposure to costs. There are no guarantees in litigation, and all litigation carries its risks. A risk of losing the case is one of those risks. Legal professionals will not be able to guarantee you results. And in the event that you're not successful in your lawsuit against the opposing party, not only will you not recover the amounts that you're seeking, not only will you not recover any amounts you've paid out of pocket for the lawsuit, you may be required to pay for the legal expenses of the other party. These expenses are known as costs. In most cases, costs are awarded to the successful party of up to 15% of the amounts that are claimed by the plaintiff, my apologies, in addition to reimbursing out-of-pocket expenses. So are we saying to sue or don't sue? Not at all. What we're saying, and our approach in litigation for any business, is to be candid, forthcoming legal professional, to ensure that our clients and litigants before the small claims court are fully aware of any risks associated with legal action and can make an informed decision.
So next we're going to turn to preparing for the litigation. So prior to starting a lawsuit, you're going to want to review all of your records to ensure that all of the available evidence, information, and facts are present, as you will require this information for the litigation. In breach of contract lawsuits, legal professionals look at the following to substantiate their client's claims. So first, we're going to look at a written contract. So I understand that it's not always available, but if it's available, you'll want to ensure that you have this written contract and ensure that all of the pages of the contract are legible and that all sides of the contract are included for your legal professional's review. So in that case, a double-sided document, you're going to want to ensure that that is included for review. Secondly, a verbal contract. So of course, your legal professional was not present for this exchange, so you're going to want to take note of all dates, times, and any witnesses that were present for this verbal contract. Third, you're going to want a detailed timeline of events in chronological order. So you're going to want to know who said what, when they said it, and how they said it. So who was present for this exchange? What happened during the exchange? When did it happen? How did it happen? These are all important questions that a legal professional will ask you. So the legal professional will then select the necessary pieces of information, but the client should disclose all of the information available to them so that their paralegal or lawyer can make these necessary pieces of information into what we'll learn more about in a little bit, a claim. Fourth, we're going to also want to collect all photographs, if there are any, that are going to be used as evidence. So make a note of the date, time, and who the photos were taken by. Text messages, a lot of people or businesses think, you know what, because it wasn't an email, I can't use it. That's not the case. Text messages are and have been lately very prominent in the small claims court, and screenshots are required to clearly show the time and date the conversation took place, and ensuring that there's overlapping screenshots are very important in order to determine and demonstrate the continuation of the conversation. So what we tell our clients is make sure that the date is included and then it continues, and on the next page, you're going to see a little bit of what the first page said, but make sure that you do have a little bit of overlap to make someone understand that the conversation is continuing. And then documentation, photos, etc. What you're going to want to do is ensure that it's saved in a digital format, if this is possible. Typically a PDF is what the court prefers, and you're going to want it organized in a concise manner. So what is important to note is technology. So as a result of the COVID-19 pandemic, the courts have switched to an online platform. Zoom is specifically what is being used to conduct hearings and settlement conferences, and the documents that are filed electronically via the online portal will be available for viewing for the parties that are at the hearing. So what's important to note is whether or not you have the technology available to you to participate in the digital proceeding. And if not, if you can make the alternative arrangements with family or friends to get on Zoom and to actually conduct the hearing, because this is going to be crucial, especially now. So what is important is perhaps considering hiring a paralegal or lawyer if this technology is not available to you or if it presents a challenge.
So now that we are ready for litigation, let's talk about pleadings. And the term pleadings actually describes the documents that each party will prepare to file with the court. The party, the business or the individual that starts the legal action is known as the plaintiff. The person who's being sued or the business that is being sued is known as the defendant. And for the purpose of small claims court, each one has a very important job to do when they start preparing their lawsuits and their defenses. The plaintiff who's commencing the legal action needs to clearly outline to the court why they believe that the party they're suing owes them any amounts. And a general structure of a plaintiff's claim follows the 6 points outlined on this slide. Small claims court utilizes very specific forms for the purpose of advancing litigation. When you commence legal action, you will need to utilize a form titled Plaintiff's Claim, also known as Form 7A. Within the plaintiff's claim, you will first state the amount or amounts, if there's multiple, that you are claiming against the defendant. What is it that you're asking the judge to ultimately grant you when you finish proving your side of the story? You will then outline the parties that are involved. You will identify your business or yourself, and you will identify the party, the business or the individual that you're suing. You will then describe the relationship between the parties. In other words, how did you and the plaintiff entered into the contract? What happened, how it happened? Followed by description of the actual breach, which brought you ultimately before the small claims court. One of the reasons that it was important, as Kimberly described, to prepare for litigation, because preparing your plaintiff's claim will be so much easier when you already have the necessary information organized in a chronological order. Once you describe how the breach occurred, who caused it, how and when, you will then need to outline the consequences of that breach. How did you, the plaintiff, suffer? Did you lose business? Did you lose money as a result of this breach? Last but not least are the legal grounds for the actual claim. And for a self-represented plaintiff, this part is probably the biggest challenge. The defendant, the party you're suing, is going to be required to provide a response. Once the lawsuit is issued with a court and served on the defendant, the responding party will have 20 calendar days to respond, failing which they may suffer dire consequences. When you fail to defend a lawsuit, you're ultimately admitting to all the allegations that are contained within that lawsuit. If you disagree with the allegations that are advanced by the plaintiff against you, the response is prepared, served, and filed with the court utilizing small claims court form titled Defense, also known as Form 9A. Within the defense, the defendant's job is to explain their side of the story in relation to the allegations contained within the plaintiff's claim. The defense follows a bit of a different structure in comparison to a plaintiff's claim. First, within the defense, we state whether or not we admit to any allegations that the plaintiff has made against us. So for example, if Kim was to sue me and she says, Olga owes me $10,000 because there was a contract and she breached it, I may admit that in fact there was a contract. I may deny the fact that I breached it. And within my defense, I would have to state that I'm denying that there was a breach. Now, there may be some allegations within the plaintiff's claim of which you have no knowledge of. Perhaps the plaintiff has not shared that information with you. Once you outline any admissions, denials, or any lack of knowledge to certain allegations, you want to list your version of the facts, your side of the story, how the contract occurred, how it was breached, by whom and why and when, followed by legal defenses. And what we mean by legal defenses is sometimes the party that does breach the contract may actually have a legal reason to do so. Last but not least, the defense will clearly state what it is the defendant is asking the court to do. And usually the defendant, denying any allegations, will ask the court to dismiss the claim against them.
So the next question, after these forms have been filled out and filed, what is next? So the settlement conference is the first hearing in the small claims court process. So a settlement conference is a mandatory informal hearing between parties that are involved in the lawsuit, and no witnesses are permitted at this hearing. The hearing will be conducted by a judge or a referee, depending on what small claims court location you are at. And there are a number of purposes for this hearing. So 1, you want to attempt to resolve the issues between the parties. 2, you'll want to narrow the issues in the legal action. So like Olga had mentioned, some of the facts that are outlined within the plaintiff's claim, the defendant might agree with. So at the settlement conference, there might be, an understanding that yes, there was a contract that was entered into, and that is something that is not of issue and that the defendant is not disputing. 3, we want to encourage settlement. So as Olga mentioned, litigation can be a expensive and again, risky process. So it's important that, if a settlement can be reached, it's encouraged so that it saves parties time, it saves parties money, and ultimately it brings a resolution to the table. 4th, we want to assist parties in the effective preparation for trial. So often what will happen is the judge or referee at the settlement conference will provide their input, such as, I see that you have a contract, for instance, for repairs for work that a contractor has done. However, I don't see any invoices or estimate to substantiate the need for these. And that's important. So the judge or the referee hearing the settlement conference often will provide some input as to what will be needed in bringing the matter to trial. And 5th, to provide full disclosure between the parties. So what's important to know is that disclosure is required when going through the small claims court process. So as number 5 notes, to provide full disclosure, what's the timeline for this disclosure? So at least 14 calendar days before the settlement conference occurs, each party must disclose to the other parties involved any information, documents, or anything else that they intend to rely upon at trial. A failure to provide disclosure 14 days prior to the settlement conference may result in an order against you for what Olga had already mentioned, costs to be paid to the other party. So in addition to disclosure, a list of proposed witnesses of Form 13A must be prepared served on the other party and filed with the court. So what will this form do? It'll outline all of the individuals that you intend to call as witnesses at the trial. And what is important to note is that the list of proposed witnesses also separates the importance of the witness. So, whether they just have some knowledge of the matter or whether they are important to the case, it'll separate it so that you can differentiate between the witnesses. But all in all, the Form 13A is purposed to list all of the witnesses that you intend to call. So, settlement conference, it's a great opportunity for the parties to speak openly and to attempt to settle the dispute instead of proceeding to trial. What's important to note is that everything that is discussed during the settlement conference can't be disclosed to others unless consent is obtained by the parties involved until the entire case has concluded. So in other words, if you agree to accept a lower amount from the other party during the settlement conference, but the other party does not agree to pay that amount, your offer of a lower amount cannot be used against you at trial. Parties are always encouraged to resolve the dispute before the settlement conference, during and after. And what this does, it minimizes the time and expenses associated with trial, as well as the risk.
So now we are past the settlement conference. We haven't settled the matter, even though I'm sure we all tried. And we now are looking to proceed to trial. Contrary to popular belief, it is not just the party that commences the lawsuit can request a trial. In fact, any party to the proceeding can make a request for trial. Why would a defendant wish to move this matter along faster than the plaintiff? Well, some parties wish to have some sort of finality to the dispute. In requesting a trial, whoever it is making the request, completion and submission of a form titled Request to Clerk, also known as 9B, is required, together with the court filing fee of $249. Fairly expensive request. It is a good idea to advise the court of any dates on which you are not available in the near future to avoid the trial being scheduled for a date that you may be on vacation for, requiring you to postpone a trial to another date. Once the court schedules the trial, they will notify all the parties involved. In today's COVID-19 pandemic environment, the notification is provided by way of email. So it is imperative that the court has your email address on file. And in abundance of caution, we recommend that the information is provided once again at the same time as the trial is being requested. Today, trials are being scheduled sometime in the summer, fall of 2022, and we're just in February. So you can appreciate the delay that the pandemic has caused. What it does do is provide us with an opportunity to reevaluate our case, to determine if any additional evidence should be obtained, and if so, we can disclose that evidence prior to trial. The rules of the Small Claims Court require parties to share among themselves and to file with the court any evidence they intend on relying upon at trial at least 30 calendar days before the date of the trial. Now, Kimberly spoke about a settlement conference, and you may recall disclosure prior to the settlement conference. This is yet another opportunity to provide additional disclosure. Perhaps it's something you've recently obtained, perhaps it wasn't available prior. The court may request copies of the evidence in digital format to be provided shortly before the actual trial by way of email. And complying with these requests is a mandatory requirement, failing which the judge hearing your case will not have the necessary information in front of them to properly adjudicate the dispute between the parties. So it's important to remember that today the trials are being conducted by Zoom. And that means your witnesses that you intend to bring at trial should also be available by Zoom. The usual structure of a trial follows the following. The opening statements. The judge will allow each side of the dispute to briefly state the nature of the dispute and outline the legal issues before the court, and to advise the court exactly what each side is asking the court to decide on. The party that commences the lawsuit, the plaintiff, will commence the opening statements. The party that brings the lawsuit has the onus of proof, and therefore the evidence will also be presented first by them. The evidence is presented through witnesses. And if you don't have witnesses, you as the business owner is a witness to the actual dispute yourself. Quite often, our clients only have one witness, that is themselves. The plaintiff will present their evidence by taking the stand, or in the Zoom court, simply raising their hand and swearing to tell the truth, by telling their story, their side of the events. And that is called a direct examination. If the plaintiff is represented, the legal representative will lead a line of questions to the witness in order to introduce that evidence. During that oral testimony, the documents that you have prepared for the use at trial will be introduced to the court and entered into evidence. Now, the opposing party, the one you're suing, will have an opportunity to ask you questions as well, and that's called cross-examination. Keep in mind that the defendant is disputing the lawsuit, so they're not in agreement with everything you're saying. The purpose of a cross-examination is to challenge your evidence, to poke holes in your story. Once the cross-examination concludes, you will have an opportunity to answer some additional questions, what is known as a redirect examination. Now, the redirect examination is only there for the purpose of providing an explanation of any particular issues that arose from a cross-examination. This is not an opportunity to repeat the evidence that you have provided in the direct examination. Once the redirect examination concludes, the next witness can take the stand. So the plaintiff will present all of their witnesses and all of their evidence first, followed by the defense. Kimberly?
Sorry, on mute there. So what happens after all of the parties call their witnesses and their evidence is led? Well, there has to be an opportunity for us to sum that up. So once all of the evidence has been presented to the judge, the parties have the opportunity to provide closing submissions. And what is a closing submissions? It is a summary of evidence presented and the making of legal arguments to the judge, after which the judge will make a final decision on the entire case, and the decision may be reserved. So in other words, at times the judge might need a moment to consider all of the evidence that has been presented and then render a decision. What also can occur at this time is instead of orally providing closing submissions, there are judges and, in more complex cases, a situation that will arise allowing parties or their representative to submit their closing submissions in writing. So after a decision is rendered, parties will have an opportunity to seek cost. So what that means is the successful party, as Olga had mentioned previously, will ask for their expenses associated with bringing the lawsuit, and the losing party will argue why the expenses should not be awarded to the successful party. As a self-represented party, preparation for trial is often a challenge and is nerve-wracking. So when we consider the cost of litigation, which may not warrant the expense of a legal representative, it's important that we recommend that parties consider hiring a paralegal or a lawyer on a limited scope retainer. So what is a limited scope retainer? So first, a full scope retainer with a legal professional means that the legal professional is assisting you from start to finish. A limited scope retainer with a legal professional means that they are hired for a specific step or a series of steps in a legal action. So what could a legal professional do on a limited scope retainer? Well, for instance, often a legal professional is hired for a limited scope retainer for the purpose of preparing, issuing, and serving a claim. So as we outlined, the plaintiff's claim is the document that allows the plaintiff to explain their story. Sometimes it's not easy for self-represented parties to organize their story in a matter that will be understood by a judge. So what will often happen is that a legal professional is hired for only that purpose, for preparing, issuing, and serving the claim. Similarly, a defendant could hire a legal professional for the purpose of preparing, serving, and filing the defense. Or, depending on the stage in which your matter is at, preparation and representation at trial. What's important to know is that planning ahead is key. We must ensure that the legal representative has enough time to prepare, especially in the instance where a representation at trial limited scope retainer is going to be discussed. It's important that the legal representative can review all of the documents, all of the pleadings, and can prepare adequately for that hearing.
So that basically concludes our presentation today as to the general process. And as I mentioned in the beginning of our presentation, this is not for the purpose of providing legal advice. It's just a general outline. We encourage everyone to obtain legal advice to their case-specific situation. You're welcome to contact our office, myself or Kimberly. In the alternative, the Law Society of Ontario, who's the governing body for all licensed paralegals and lawyers in the province, offers a free service to members of the public, and that could be for businesses and individuals. The Law Society Referral Service Program will connect you with a paralegal or a lawyer subject to the type of legal problem that you're facing. And that lawyer or paralegal will provide you with a 30-minute free consultation specific to your case. Are there any questions that we can answer?
Thanks, Olga and Kim. Yes, there is. Laura has a question in the chat box. Laura, do you want me to read it or do you want to unmute yourself and ask?
Oh, hang on, I'm just reading it.
Okay.
Laura, if it's okay, I'm going to read it out loud.
Okay.
So Laura asks, I don't know if, but do business insurances set up by small businesses cover these legal claims costs? And if so, what kind of business/legal insurance do you recommend for a small business to have? Okay, so, and there's additional questions. So Laura, let me answer the first question. I'm personally not familiar with the legal insurance plans, though I do know that they exist. And some of the feedback that we've heard in the past from individuals who have utilized a legal insurance plan is that they were limited to the type of services that were covered. What I would encourage you before signing up, as with purchasing any product from any service provider, is ask the appropriate questions. Not only what you're going to be paying for that insurance plan, but what is included and what happens when you exceed any potential monthly limits of services, or how much do additional services cost outside of that coverage. From what I have seen in the past, usually those plans cover such thing as demand letters as opposed to litigation. Your next question was, based on your experience, how do small businesses pay or allocate for the unexpected legal fees? Well, it's a challenge. There's no doubt about that. In operating a small business for over 20 years, we usually budget for a rainy day fund, so to speak. And it obviously depends as to the size of the business. Believe it or not, legal professionals also face sometimes lawsuits, and we have our own set of lawyers that we hire. It would be treated as any other business expense, and I encourage you to discuss that with your chartered accountant professional. I believe, Teresa, there's a number of partners that offer those services. I believe one of them is actually my chartered accountant. He's fantastic. But it's something that I would recommend, maybe, you know, almost like a piggy bank that you allocate each year, and hopefully you never need those services. You know, as much as we welcome new business, we're not always thrilled as to why businesses need us in the first place.
Right. I hope that answered your question, Laura. I didn't know the kind of business you're in. Has anybody else got any questions about the whole process? The small
If I
claims
may
court.
just add to what Olga
Yeah.
was saying there. So I know that we touched on costs very briefly, but it is important to note, let's say that you are a business that is pursuing a claim. And as we discussed at the end, if you are successful, you can request costs in the amount of 15% of the amount claimed. So for instance, let's say that you are 100% successful in proving $35,000 worth of damages. What's important to note is that, as Olga mentioned, the small claims court jurisdiction is $35,000. However, you also can ask for costs on top of that amount. So what that means, 15% of 35,000, that's over $5,000 that you're going to be requesting back to assist in the payment of legal fees. So that's something that at the end of the process can definitely help in, you know, recouping some of the losses that you have incurred for legal fees.
Great. From the sounds of it, it's not a quick turnaround.
Unfortunately not. And as I mentioned, COVID-19 has delayed things even further. And then that's one of the reasons why we don't encourage businesses or our individual clients to jump into litigation head first. You know, we approach it from a very realistic perspective. Is said, is it worth it? How much time is it going to take? What are the chances of success? What are we looking at potential recovery? Can we recover?
Right.
And unfortunately, it's heartbreaking. We understand that, but we've had businesses that advanced lawsuits and they were successful for the whole monetary jurisdiction of small claims court, $35,000, but unfortunately, they weren't able to physically collect that money.
Yeah.
So
I've heard of that before for sure. So
yes.
I guess some of your, as a business owner, some of your stopgaps could be to make sure that the contracts you have in place with your customers are or if you don't have any, to have those contracts in place first. And depending on the type of business you are in, especially as a small business, try and collect some money up front. Use that as a guarantee that they're buying and committing to you, and get that money up front as much as you can, for sure. Jamal has a question. Hi, Jamal.
Oh, hi, good evening, everyone. Yes, so I'm just wondering if a claim is successful, how long does the defendant have to reimburse the funds for that claim? I understand Olga was saying sometimes the pursuing of the defendant, they may not have the funds, they may claim bankruptcy and things of that nature. But if they didn't claim bankruptcy, how long does the claimant have to gather those funds back, those funds that they've been awarded in the court, for example?
That's an excellent question, Jamal. Excellent. So I can tell you that the judgment, the order that you obtain from the court never expires. It's good forever. That's the good news.
Okay.
The bad news is that if the defendant is not paying you, and it happens, they're not reaching into their pocket to cut you a check, you're going to have to take additional steps and incur additional expenses to try and enforce it. And I mean, we can definitely do another presentation for that. But one of the ways to enforce it is, if you know where they're banking, we can garnish their bank account. If you know if they have any assets, we can try to seize and sell those assets to recuperate that. If they own any property in a particular region, we can issue a writ of seizure and sale of land. So there are a number of recourses, but again, it takes time and money.
Yeah, and just to follow up to that question, is the payment due in full, or is it an incremental payment system, or is all what the defendant can afford at the time of the awarding?
Well, so let me take you back a little bit. The best answer you're going to get from a legal professional is it depends.
Right.
Yeah.
Yeah, exactly.
I think Teresa has heard that before. Yeah, it's my favorite answer because it truly does. It depends. So when you're successful in front of a judge, you're actually going to get an order saying Olga has to pay you $10,000 plus cost, disbursements, and interest. And that order is actually requiring me to pay the whole amount. The question is, can I afford to pay that amount?
Exactly.
And I may start paying you $50 a month. You may wish to bring me back in front of the court for what is known as a debtor examination. And that's what we call a fishing expedition. And a debtor examination in front of a judge, you're going to put me on the stand and you're going to go down a very lengthy list of questions where you're going to ask where I bank, where I work, what assets I have, and so forth, to try to figure out what you can take from me in order to get paid faster. So I know Kimberly has done a number of those. Did you want to add on that debtor examination?
So you explained it quite clearly. What I did want to add is that, as Olga had mentioned, interest is also payable on the amount that is ordered. So let's say that a few months pass by, daily interest is incurred on the amount that's ordered. So it might not be exactly what you're expecting. Maybe you wanted to, get paid when that order was issued, but there are post-judgment interests that gets added to the judgment in order to attempt to assist in compensating for the delay.
Right.
Did that answer your question,
Yeah,
Jamal?
that's really answers the question, guys. I appreciate that. Thank you, Kimberly and Olga.
Absolutely.
Thank you. Don't know if anybody else has questions about the whole process, but yes, I think both of you, Kimberly and Olga, you very detailed information. Thank you.
Absolutely.
And I hope that if anybody needs some help, you can reach out directly to Olga and Kimberly, and appreciate you being with us this evening.
Thank you very much. And if there's particular areas that we can discuss further, please let Teresa know. We're more than happy to come back and make another presentation on a particular topic.
Okay.
If I can just make a follow-up comment.
Sure.
I know, Teresa, you mentioned before Jamal's question about contracts and small businesses. I know a lot of businesses, just from litigation, they shy away from spending money in creating contracts, utilizing lawyers, or having lawyers review the contracts. While again, we welcome new business like any business would, but my recommendation would be to spend that money on a competent lawyer for the purpose of reviewing contracts or creating your contracts specific to your type of business to minimize the potential legal expenses involved later on, and to minimize or to maximize the chances of success if litigation has to occur later on. Oh, sorry, I saw there was a question by Laura.
But I do agree with you, Olga. Even if it costs you $300, $500, $1,000, it's probably the really good money spent.
Absolutely.
And you know, it protects you for a long time.
Yeah.
Thank you, Olga. Yes, read the question there.
Yeah, so Laura, is it possible to put a cap on the legal fees depending on the nature of the case, or are they billed per hour? So it depends, but yes, it's possible. Most of the time, legal professionals will charge on an hourly basis, and there are advantages to paying on an hourly basis. Legal professionals, let's say, hypothetically, it's $200 an hour, but we don't bill for the full hour. If it takes me 10 minutes to prepare a document, you're literally paying for that 10 minutes because I'm keeping track of the physical time that I spend. Whereas other legal professionals may charge what's called as block fees or fixed fees. And that means that for me to prepare your claim, let's say I'm going to charge you $1,000, but it may only take me an hour to prepare your claim. So on an hourly basis, it would have been cheaper as opposed to a fixed fee. We understand the concerns that a lot of clients have because the hourly rate, it sounds expensive, but more importantly, it's uncertain. Because we don't know ahead of time how much time something will or will not take. Though most legal professionals who have been providing services for some time, we can estimate. You know, if you talk to us and it's more or less of a straightforward issue and all your documents are there, we can estimate as to the amount of time it will take. If you come to us and you have, 500 pages worth of documents, then it will obviously take a longer to review everything and to prepare the claim. Feel free, when you're looking for a legal professional, interview them as you would interview a potential employee at your business. Ask them about their experience, ask them about their fees, how they structure it, ask any questions. Don't be shy. You are hiring them to provide a service to you.
Fantastic. Thank you. Any other questions, anybody? Otherwise, we can bring this evening to a close and this session to a close. Thank you so much. I appreciate it.
Thank you. Thank you. Thank you for having us. We're more than welcome to come back.
Thank you so much. Have a good day, everybody. Have a good night.
Bye-bye. Thank
Bye.
you.